Lawyer Eileen Lee. Ms. Lee is also a member of Parliament for Sembawang GRC. Ellen, as we have seen, different banks have different definitions for what they call vulnerable customers. Should these customers who've been offered compensation take it?
I believe those who have been offered compensation should really seriously consider taking them, because at least they will cut out more waiting, more anxiety, and possibly more costs and time wasted in wanting to pursue the matter further. But again, it is an individual decision. But overall, because of the uncertainty in the landscape, if they think that the compensation is enough or sufficient compensation for them, then I think they should seriously consider accepting.
What about people who don't fall under these categories? What recourse is there for affected customers, like those who fall out of these categories?
Well, for those who fall outside the categories of vulnerable investors, I think they could also still approach FIDReC for redress, because that is one of the suggestions that has been proposed by MIWs as well. And in fact, the whole process has been fast-tracked to help them resolve the claims and the situation. But if they feel that they do not want FIDReC to be involved at all, then they could consider taking up civil suits against these financial institutions. But the downside to that would be that it could possibly take months or maybe even years, because our legal system is adversarial in nature, which means that they will have to prove, have enough proof to show, or enough evidence to show that they have really been misled and that the whole thing has been defective right from the start.
Now, if investors ultimately receive an offer from a third party to take over the notes, should they accept it?
Well, again, it depends on what has been offered by the third party by way of compensation. And if after weighing all the pros and cons, they feel that the compensation will be more advantageous in that it will cut down a lot of expenses to be incurred, anxiety and heartache and all those things, and uncertainty as well, then they should also consider taking it.
Now, coming back to FIDReC, why is it preferable for them to go to FIDReC, in terms of, other than the fact that it probably will take a shorter time?
Well, in this particular case, I think FIDReC has been well poised to settle this dispute. And the chairman of FIDReC itself is the retired High Court judge, who is very well respected in the profession and by the industry as well. It will cut out a lot of process that you have in court, in having to file documents, in having to have examinations, cross-examinations, and things like that, and then wait for the uncertainty of a trial. So FIDReC has actually cut down on all these things, and you can actually allow the investors to have their say in court, rather than to have to abide by a set of rules if you were to have this matter settled in the civil courts.
Now, you're a lawyer. What would you do if you were one of the affected customers?
I will go to FIDReC. I will go to FIDReC and I will put forward my case, because that's when I don't need a lawyer to come and tell me or to forward my case for me, because each case is different in that sense. I will be able to tell without having my side of the story, without having to be bound by the rules of court, by having to be ruled out of by the court to say it's either irrelevant or it's not in point and things like that, because the whole thing is configured to solve this problem, and this is the best way forward.
Thanks very much indeed, Ellen, for your time on the show tonight. And that was Eileen Lee, a lawyer on the legal options available to investors affected by the Lehman Brothers linked structure.